Hi, I'm Greg Hunt and welcome to No Disputing That. I created this podcast to give you an in-depth look into the world of mediation and arbitration. Each episode I'll be having a conversation with one of the most renowned names in the field, plus some you may not have heard of yet. We'll cover a wide range of topics from ADR to other areas of the law and life in general. So get ready for a unique blend of thought-provoking discussions, plenty of laughter and occasional audio slip-ups. Today I welcome Rob Langley to the show. Rob is the man you need to help you to find solutions to your problems or conflicts in the fields of construction, engineering and insurance. In this episode of No Disputing That, I've asked Rob to identify 5 of the leading pieces of case law relevant to mediation. Rob discusses these and we cover other issues like compulsory mediation, being sued, and of course the current ascent of Newcastle United.
Yes, I can hear you, Greg. Good afternoon.
Hi Rob, how are you?
I'm very well, thank you.
Good. And where are you this fine day?
Well, I've been in Bristol for 4 days training, but today I'm in Newcastle again.
Ah, lovely. Yeah.
So I'm back in my luxurious office.
Nice and bright and shiny Newcastle at the moment, isn't it?
It has been, but it's grey now. So
how is it? Yeah. Have you been there? It's lovely. I've actually got lovely blue skies here at the moment. It's very nice. But I've been trying to look out for that comet of an evening, and it's been too cloudy.
Oh, I hadn't realised that was happening.
Yeah, I know. There's been a comet that only comes around every 50,000 years. So I know we're both pushing it now, but neither of us were around last time it was. It could be seen.
Oh, you're that really bright thing in the sky.
Yeah.
Just before the last ice age, of course. Yes.
Yeah.
You wait 50,000 years and then 2 come along.
I was getting really annoyed though, because it's a green comet and you're supposed to be able to see it, particularly the last 2 nights. And I was getting really annoyed because I really wanted to see it. And I thought, it's only every 50,000 years. And then I thought, and this is a bit deep now, I thought, yeah, but this actual moment I'm living in now has never happened before and will never happen again. So who cares if it's every 50,000 years? Because what we've got now is unique.
What we've got now is what we're given.
Exactly. And that was the deepest I've ever got on any episode of No Disputing That.
There's a Bible in the post.
Yeah. Okay. Right. Well, look, as you know, but I'm going to tell everyone else who's listening. I have tasked you with coming up with your top 5 or 6 bits of case law.
Yes.
That you think is relevant to mediation, and this is on the back. You've already done a video for me, which we use with students sometimes to sort of explain to them bits of case law. But I thought it'd be really good content for a podcast.
Okay.
Because a lot of mediators listen to the podcast. A lot of newly qualified mediators listen to the podcast, and a lot of people who aren't lawyers and who, like me, find case law something that is just alien to them, because it's just, if you don't think with that sort of mind, it's quite difficult to keep on track of what's important and what's not. So I thought it was a really good opportunity to ask you to talk through some of the most relevant bits of case law.
Great. Well, thank you very much for this opportunity, Greg, to talk about my favorite subject, which is mediation. And I also love case law. You have to have a strange sort of mind full of small boxes, I think. So Dun and Railtrack it's 2 fantastic things. First of all, you're 10 years into the whole ADR struggle. It's come over in the States in the early 90s. More and more people have got on the bandwagon, including people like myself and yourself. And we're all thinking this is the future, but the judges are really resistant and the profession isn't convinced. And then the Court of Appeal lights this beacon and says, this is really important. If you refuse to use this, we may sanction you. And then they set up the mechanism that actually legitimizes the use of costs to sanction refusals to mediate, which is Civil Procedure Rule 1, the overriding duty of the courts to act justly and at reasonable expense or proportionate expense. Secondly, and that overriding objective is the duty of the court as well as the objective of the court. And then CPR Rule 1, Sub Rule 3 puts a duty on us as litigants, as parties to the process, to actively help the case, the court, to manage its cases, to pursue the objective, which means settling cases at proportionate expense, i.e. deploying ADR wherever appropriate. So it lays the intellectual foundation that justifies the whole process and creates the court sanction, which does effectively drive a lot of litigants to participate in mediation. And then the judge, if I needed an elevator pitch for why someone should appoint me to provide, or any of us to provide a mediation service, it's what Lord Justice Brooks says. He says that to talk about not being willing to settle because it would cost too much and you don't think you've got a real vulnerability and you've got a great case. He says that's a misunderstanding of the purpose of alternative dispute resolution. The mediators can achieve results satisfactory to both parties, in many cases which are quite beyond the power of lawyers and courts to achieve. That is so true. I mediated a really bitter dispute about a large hedge between two big properties the other day. Neither party could agree where the boundary line was. We even tried with bits of string to draw it up. But actually, at the end, I finally said, look, why doesn't one of you just buy the plot of land off the other? And then one person's got the hedge, but they haven't won because the other person's got some money. So both sides can think they've won. There's no way a judge could say that going halfway through the trial. Plus, we were about a third of the way into a £60,000 per side litigation spend. And so we saved both parties a lot of money. They both went away with a solution. And all the stress and the grievance was gone. And then when the judge will also say, the mediator can get a result where the parties shake hands at the end and feel they've gone away having settled the dispute on terms with which they're able to live. A mediator can provide an outcome which is beyond the power of the court to deliver. And people are skeptical about that, but you and I will have seen this so many times.
Oh yeah, definitely. Yeah. I mean, I'm not going to sort of go into detail now because it'll take too long, but there's a case I love talking about. So I'll just say at the end of it, one of the lawyers turned to me and said, thank God we went to mediation because that would have been a 2-week trial. Costs would have been in the 6 figures, and no one would have a clue which way the judge would have come down. And we settled it in 3 hours at mediation. So, and there's countless examples like that through mediation and speaking to mediators and parties about the benefit of it.
Well, as litigators, I mean, we joke about huge bills and winning cases and so on, but actually what most of us genuinely in good faith want for our clients is resolution. And closure. And if we can get that without risking everything and stressing our clients, then that's a fantastic outcome. But 2 years later, a differently Court of Appeal in Halsey versus Milton Keynes, where again a claimant who had a poor case repeatedly asked for mediation and was turned down, and she then stood up and asked for costs because the defendants had refused, and the judges said no. But they set out 7 criteria upon which they would evaluate whether or not, if I lose a case and the other side's refused to mediate with me, and I stand up and say, we could have settled this in mediation, I've lost now, but I don't want to pay the costs because they should have mediated, citing and relying on done it. The judges said, well, really, costs follow the event. So if you want to persuade us that costs don't follow the event, you've got to prove on the balance of probabilities that the mediation would have been worthwhile. But this, rather than just being vague, they set the 7-fold tests. And they also, before they got into that, expressed a real worry that the European Court of Human Rights Convention, sorry, the European Convention on Human Rights, set this this right to have a fair trial. And if we are obliging people to go to mediation, are we denying them a fair trial? The judges were very worried about that, and it clearly influenced the way they expressed their criteria. And I think it's worth mentioning what the criteria were, perhaps.
Yeah, please.
Okay, because some of them I think have already eroded. So does the nature of the case make ADR inappropriate? Well, if I want a divorce and you don't, then it's a binary decision. You can't really ADR that. Was the refusal despite court encouragement to mediate, which it was in Dunnett, when the Lord Justice of Appeal gave leave to appeal to the Court of Appeal, he remarked that this was a case that ought to mediate. And Railtrack foolishly decided to disregard that judicial advice. 3, whether the mediation would cause delay. So we spent 2 years getting ready for trial. We've spent hundreds of thousands of pounds. We sent the briefs to counsel. That cost is sunk. And then at the last minute, I say to you, oh, let's not go to court. Let's mediate. It's just too late. It will be disproportionately expensive. So we have a small dispute, which would take a day in mediation with barristers and solicitors on both sides. It's cheaper to go to court than to mediate in some circumstances. I can see that. We've already tried early neutral evaluation. We've already tried having a structured negotiation between our boards of directors. We're not going to mediate this. That would be a fair thing to say. But the last one comes in 2 forms. Either the mediation could have had a reasonable prospect of success, or the other side of the same coin, the refuser reasonably believed he had a strong case. And that's something that's been eroded. There's a number of cases. One of my other favorite cases, I'm just sneaking in, is DSN versus Blackpool Football Club, where actually the court changed the law on vicarious liability as a result of that case. So the defendant had a very good reason for saying, look, the law is against you. This person wasn't our employee. We're not vicariously liable for him. Go away. We're not mediating. And the court said, actually, this person was a volunteer in the position of an employee, so you're still vicariously liable. So the law changed, and then the football club had to pay DSN's costs, I think on an indemnity basis. So that's another one of my favorite cases. As an evangelist for mediation. What's also quite encouraging is that the High Court's slowly losing its fear of Article 6 of the Convention on Human Rights. A case called Lomax, and Lomax, again, I said the High Court, I should have said the Court of Appeal, Lord Justice Moylan said that early neutral evaluation ordered under Civil Procedure Rule 3 was not a breach of the Convention because it was a step in the process rather than a blockage to or an ending of the process. It's simply that along your way to court, you can be asked to go down the tunnel of ADR first before you reach.
So you're not losing that right to still go to court.
No, no, exactly.
Other options before you get there.
Exactly. It's just there's another flight of steps. It's like you think you've got to the top of the hill, and there's another rise in front of you. The top's still there. You're still going to get there. So Lomax, I think, is another one of my cases that make me feel that we are very slowly winning the fight. And then Invesco versus Open, that was another landmark case. That's a case where the parties agreed in their contract, their commercial contract, that if had a dispute or difference, they would take it to mediation. And it was a very well drafted clause that said precisely how you would take the case to mediation. You therefore had sufficient certainty as to what the obligation was. And my favorite judge, Mrs. Finola O'Farrell, she actually found that it's perfectly possible to create a condition precedent so that I can't actually go to court until I've mediated with you. Our mediation has failed, and then either of us has the right at that point, but not before to actually start process. So I think the idea of conditional access also, the judges are no longer worried, takes us into the realms of breaching the human rights. I'd like to just wander off the theme that I've been pursuing so far in a case called Orgler versus Orgler, and that's, if I don't know if I pronounced that right, that was in Reading County Court in 2022. So very small case before a district judge. It's found its way into the reports because of the subject matter, and that's where 2 business people negotiate in a mediation before a mediator appointed by CEDA. So a very competent mediator, and there's counsel on both sides and solicitors on both sides. And after the agreement's been signed and the Tomlin order's been filed with the court, one of the parties decides that he doesn't like the deal. So he says he raises a defense of duress to the enforcement of the Tomlin order and says that the mediator subjected him to duress. And the judge looks at this very carefully, and she finds that this mediator had been, quote, very robust. She finds that the mediator had shouted at the claimant, shouted at the barrister, stressed the weaknesses of his position. Nevertheless, that wasn't undue influence. It wasn't nowhere near duress. It didn't prove bias. She said the mediator was pugnacious and forceful. He raised his voice, but that does not come close to constituting duress. I've mentioned this case because it actually worries me, because it demonstrates something I've often thought when working with lay clients in mediation, which is that if I'm the only professional person in the room and the lay clients, one of them or both of them decide afterwards they're not happy with the deal, and as you've probably told people, and I always tell them, most mediation settlements sting both sides. They leave both sides going a little bit further than they actually are comfortable in doing.
Yeah, there's no such thing as the theoretical win-win, is there, in real life?
No, there isn't. It's always a tragic situation, and there's always loss. But my worry is that sooner or later somebody is going to make me earn my professional indemnity insurance premium by actually accusing a mediator of undue influence. We trusted you. You said you wouldn't pass things on, and you let us down, and it was a terrible deal. And then you drafted it, and it doesn't work. So it's great that certainly if you have a trial in Reading County Court, you'll get a good, robust defence of mediation. And it's probably not a good idea to shout at your mediation clients anyway.
No.
I think that is a sign of the times, that as mediation gets more common, sooner or later we're going to find ourselves exposed to this sort of unpleasant allegation. We just need to be wary of it when we. I would hate to see the day when we started practicing defensive mediation techniques.
Yeah. I think the thing to bear in mind there is, as mediation gets more and more popular, more people are using it, more people will by nature be unhappy with the outcome, because I see it when we deal with our travel claims. When there was COVID going on, no one was going on holiday. There were no disputes. Now there are plenty of disputes because people are going on holiday again. It doesn't mean that the industry is any worse or better than it was at any given point in time. It just means when you've got a lot more volume of something, you've got a lot more opportunity for people to be unhappy with the outcome. So I think you're right. As mediation becomes more and more used, there will be more people who want to test things like duress. It's natural.
Right. And that is one of the trends in mediation. I think the main trend, and the one that I've been talking about just now, is the trend towards a greater and greater willingness in the courts to encourage, support, and indeed, if necessary, compel mediation, which of course is the subject of the recent Civil Justice Council report on small claims mediation. But there's a straw blowing in the wind in the opposite direction, which is there's a case called Churchill versus Merthyr Tydfil Borough Council, in which the council has identified a real problem with lots and lots of small claims being brought against it in the courts, which require a lot of expenditure on legal fees, when the council has what it considers to be a perfectly adequate internal complaints procedure, which can deliver the same outcome at a lot of expense. And in a particular case involving Mr. Churchill's claim, the council is actually resisting enforcement of the judgment he's obtained and going to the Court of Appeal. And they intend to address and if possible review the decision in Halsey versus Milton Keynes. And it's fascinating to see how they propose to argue this. I can't quite see how they're going to do it, but it's going to be one case that we need to look out for in 2023. With in effect, it's like The Empire Strikes Back. It's a public authority saying we shouldn't be being taken to court. We should be going to using ADR techniques. In effect, it's actually I think I slightly had the wrong end of the stick there. It's actually you've got a public authority saying no, ADR is great. Let's use more ADR. Let's, instead of having to kind of jump through all these hoops, can we please just sustain the court's approach? So instead of putting difficulties as the presumption, the burden of proof puts a difficulty onto the person who's lost the case, wants to rely upon having suggested mediation, and wants to therefore recover their costs, as DSN did and as Mrs. Dunnett did. They're trying to actually set aside the presumption in Halsey that you can't actually get your costs unless you can prove, on the balance of probabilities, that the matter would have been usefully referred to mediation in the first place.
That's an interesting one. I think there's lots of cases over the years that I've dealt with in various roles where there's been a volume number of cases against an organization or authority, and they've introduced low-cost arbitration or low-cost mediation as a way to get quicker outcomes than having to go through court. And generally that sort of technique works. So I think, if I understand what you're saying there, if Merthyr Tydfil are successful,
yes,
they would be able to go down that sort of route where they could say, right, any disputes that come in of this nature, we're now going to refer to an ADR scheme that we've set up to deal with this.
And obviously, as long as you kind of tick the Invesco and Open box, and you're not actually saying you can't go to court, you're simply saying this is a step, please take this step first. I actually think that addresses what I've always thought was the mischief in Halsey. I was very disappointed when I read Halsey 2 years after Dunnett, because I thought Dunnett was like the start of the new age, and then the judges in Halsey come and go, oh, hang on, what about the Human Rights Act? Hang on, let's put the burden on the person who wanted mediation to prove that would have made a difference. I'd rather reverse that burden and say, I can prove why I didn't mediate, because it was a waste of time. I think that is an argument which naturally falls in the mouth of the person who's resisting paying the costs, not the other way around. So I would hope that if all the kind of rumours and omens are true, then this Merthyr Tydfil case could actually, if you like, perfect Dunnett. Give us an open highway to develop more mediations.
And we'll say, you've only gone and done it. So I have to get a corny joke in. Just going back to
bad joke, Greg.
It was, wasn't it? It was. Well, for me, it was a good one. Going back to the Reading case.
Yeah.
Do you know if the mediator had to actually take part in the proceedings?
I'm pretty sure that he didn't, because District Judge Harrison reviews all the evidence. And she had evidence from the chap who's trying to set the determinant order aside for duress, and also she allowed at the last minute evidence to be allowed from Miss Seal, who was the barrister representing this chap. And her evidence was that she didn't think there'd been duress as such, but certainly the chap had shouted and used very forceful conduct. So no, I don't think I don't want to repeat the chap's name over the podcast. It's in the law. It's in the law report. But
it's interesting. It's interesting to maybe think about whether what the mediator's view is on it, and as not picking on Cedar, they happen to be the authority who appointed at the time. It could have been anyone else. What their view is on it as well. It's
absolutely. I haven't seen anything by them on this. What do you think? Would you rather be called to give evidence and have the chance to speak, or would you rather just keep out of the way?
I think I would rather not have to. But I've never experienced it, so it's not. If I was a lawyer and I've been in court a lot over the years, and It's different when it's about yourself.
Yes.
But I would have the experience of knowing what's going to happen and everything.
Exactly. Yes.
For me, it would feel like a lot of pressure.
I think it would be a lot of pressure, and I have
Yeah.
examined twice, and both times, I mean, I'm a former barrister who actually I requalified because I wanted to specialize in a particular area, and I wanted to stay up in Newcastle. And I thought I knew the system, and both times the barrister kind of the system's loaded. You're not allowed to just make a speech. You have to stand there like an Aunt Sally in the pillory and be asked leading questions, and you're rarely allowed to just unpack the whole thing and say, "Look, this is what happened." So on the basis that you're only going to get the usual rather unsatisfactory outing, I think I would rather stay away from the limelight.
Yeah, and I think the other thing for me is like genuinely, I will have forgotten
Yes.
most of what happened. You know, genuinely, it's one of the great things for me about mediation, about being a mediator, rather than in other sort of dispute resolution techniques, is you literally do the mediation, put it to bed, shred all your notes, delete everything from your system. That case is gone.
Yes.
And when I do that, it's gone. It's gone out of my head. So if I was being called to give some evidence months or a year later, or however long it would have been, I genuinely think I wouldn't be able to offer much.
That's so true, and thank you for saying that, because that's very frank and it's very true. But an awful lot of people would bluster and say, "Oh yes, it's indelibly printed on memory," which is nonsense. And I don't know what I was doing in Thursday, the 14th of March, 2021. Who knows?
Well, yesterday even.
But that is one of the joys of being a mediator.
The thing as well, it is, but also it's when you're in a mediation, you're going from room to room, you're having meetings with people, you're having discussions, and it's very fast, and you keep notes and you make sure that you're getting things right, and you're moving it on at pace. And sometimes when I'm teaching students mediation, say, at certain stages you are literally running around, and you can't remember what happened and who said what at the end of it. All you know is what you've performed on the day. Now, if you know you've made a mistake, that's different, because I think if you know you've done something wrong, or if you know on that particular party you did say or do something which you shouldn't have said or done, then you're probably going to remember that.
Yes.
But if you don't remember it for being anything spectacular, you're just not going to remember it at all. I mean, I use case studies from mediations I've been involved in when we do training, and they've been changed. The names have been changed, the amounts have been changed, locations have been changed. And people sometimes, well, every course someone will say, "How did that settle in real life?" I haven't got a clue. I've been through it so many times now as a role player, and I've changed the information in it. I can't remember.
Yeah, you don't need to.
Or not, or anything else. I just wouldn't know.
Our brains are very effective at just not carrying stuff they don't need.
Yeah.
I once studied celestial navigation and learned how to navigate by the sun and the stars. And I still in theory, but in practice, you gave me a sextant, I wouldn't remember which way up to hold it. Memory just fades. But I think of those cases, you see this theme that mediation's mainstream now. I think it's just fantastic. And a lot of that is down to Lord Justice Brooks, bless him. This salesman.
So to end then, if mediation is mainstream, which I agree, it's certainly there. It's 90% of the way there. What do you think about the plans to make mediation mandatory for disputes under 10,000?
I think it's a mistake. I think it's a dead end. I think actually, I think there was well, Lord Justice Dyson summed it up. He was a wily old bird, and he said, "It seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on the right of access to court." I mean, I haven't done loads of mediations. I've mediated about 60 times,
mm,
mostly in the last 4 or 5 years.
mm,
And I've only twice had truly recalcitrant parties, and it's just horrible.
mm,
But just sit there and they do not want to cooperate. I think there's a bigger, so sorry to answer the question, I think compulsion is a mistake. And
mm,
I'm also very skeptical of what the CJC thinks it would be an adequate form of mediation. I
mm,
think just kind of force people to talk to one of the court clerks over the phone for an hour. That's not a proper mediation process. There's no room for
no,
recognition of reality. There's no room for a grieving process. There's no sort of proper venting and expression of
mm,
grievance. There's no room to sort of move people's attitudes away from confrontation and towards empathetic recognition.
mm,
Not very good at the jargon, but I deeply feel that mediation is, I'm going to sound glib, it's a human process. And
mm.
there's got to be a degree of humanity to it, and that it's not just a transaction. I
Yeah.
think our
No,
biggest,
I agree. Yeah,
I
I
think,
agree, and I'm worried about the whole infrastructure for it,
yes,
because it won't be set up properly, and I just think it's one of those things that sounds like a good idea, but actually, when you look into the practicalities of it, it's not a good idea, and for all the reasons you've said, and I just think I would much rather see mandatory education about the benefits of mediation.
yes,
And I remember years and years and years ago, when I was still at the CIR, there was a mediation pilots that were taking place in places like the Central London County Court and other courts, and all the big providers supported it. So there was CEDA, CIR, Clark's Room, ADR Group, and others, and we all worked together to try and make it work. But part of it was that the courts would give information out about mediation and give parties the opportunity to go to mediation.
yes,
And then all that just seemed to stop.
yes, it did.
And now people are going to be told it's compulsory. But what's compulsory? Because it's not mediation as we know it.
Absolutely.
And then if it's not implemented properly and it's not followed through properly, then it's going to set the mediation industry back, because people will say, oh no, that was a load of rubbish, that didn't work.
I tried mediation, it was a waste of time. Don't talk to
Yeah,
me.
yeah,
You'll get lawyers saying the same thing.
yeah,
And
absolutely.
I think one of the other problems we have is that as mediation has become mainstream and lots of lawyers are doing it, they're being educated in how to do it first. They're getting the wrong end of the stick. And I mean, I'm disturbed by the number of lawyers who will not have opening sessions now, and they won't try and persuade or explain to the other side how reasonable their case is. Because I frankly think there's a lot of laziness and a lot of ignorance. People don't want to take the time to master their case so they can make a convincing speech. And they don't want to sit through a speech by the other side because they don't want to listen. And that's a really bad start to a day in mediation.
Yeah. I've noticed that before. I've commented on this before. It's a trend that I think has started with online mediation. And I haven't got a problem with me. I like mediating by Zoom and stuff like that. I think it's good. It's good, and it might not be 100% the same as doing it in person, but it's pretty close. And you can work it very well. And now people are used to it. But one thing I would say is I have seen a trend, and I've asked others about this as well, where they've noticed that parties are less willing to do a joint opening statement, a joint opening meeting when it's online, than if they're together in person. So I don't know why. No one's ever explained to me why, but it definitely is a trend.
Well, I mean, I'm sure we've all got war stories to that effect. Very nice young lawyers who are great and easy to work with. And then you say, "So how have I got your? Are you ready for your opening statement yet?" And they'll say, "Oh, that's a waste of time." You can't really go behind that.
No.
You're not allowed to smack the parties.
No. Well,
Yeah.
no, because as you saw in Reading, you'll end up in court.
Yes, you will. Yeah, for being pugnacious. Yes.
Yeah, yeah. But still, I think the answer to that is education.
Yes, absolutely.
And I know you're involved at or you have been involved at university level.
Yes, I am. Yeah.
Students. I'm involved with a couple of universities, sort of in law and in Ulster international commercial law, and sort of getting them to appreciate the benefits of mediation and actually doing a fully accredited mediation course as part of the course. So when they go into the world as mediators, they're armed. They know all about it. They can explain to the clients all about it. They'll know how mediation works. They'll know why the process works. It's not all about process, but the process is there for a reason.
Yes.
When I was taught to mediate by CEDA and by CIARB, those models were originally taken from Harvard. They're implemented because they work.
Yes.
And if you follow the process, you've got a better opportunity to resolve the dispute. And part of that is to start with a joint opening meeting.
Yes, it is. For half a dozen different reasons. Yes.
Yeah. And if you take that away right at the beginning,
yes,
you're already fighting the process in a way.
It's like saying to a painter, I'd like you to paint my house, but don't use rollers.
Yeah.
And use a small brush. I know big brushes are a waste of time. How do you know these things?
Yeah. Which is quite apt because I've been tasked with doing our kitchen this weekend. And I have bought rollers and brushes.
Okay, don't forget the turpentine.
No. So Rob, to end, I have to ask you on some uplifting news. Are you a Newcastle fan?
I'm a fellow traveller. I love it when the team does well, because when a team does badly, everybody's so unhappy. My wife we got some Ukrainian guests staying with us, and the girl, she's 15. She's joined my wife's local explorer group, so they were go-karting the other night, and as they drove home past St. James's Boulevard in Newcastle, she was surrounded by 10,000 happy fans, all singing and wandering slowly along the road in front of the car. And this Ukrainian girl never seen anything like it. So that was a nice side of English culture.
Yeah, no, it's nice. Well, they've got to the cup final for the first time in a long time, so we'll see how they get on with that.
It's scary because I remember in the 1970s when we got the cup final against Liverpool and they thrashed.
Yeah. I'd like to say I remember that. I was too young, but I do remember the aftermath of it, because within a couple of months, Bill Shankly resigned, and that's my first memory. Like my absolute first memory is sitting watching the news, and Bill Shankly resigned, and I remember crying, and I was about 4 at the time, and
son of Liverpool, your star will rise again.
That's it. Yeah. Excellent. Thanks, Rob. Really appreciate your time.
Thank you very much, Greg. Good to speak.
Good to speak to you. See you soon.
Happy mediating. Bye-bye.
That's all for today from No Disputing That. I hope our discussions have helped you to learn more about the world of mediation and arbitration. As we come to a close, I want to thank you for listening in and thank my special guests for their insightful advice and ideas. If you have any questions or feedback, please feel free to leave me a voice message, and you might even be featured on a future episode. Until next time, this is me, Gregory Hunt, signing off. Thank you so much for joining me, and have a wonderful day.